Today we will be hearing from the Jamaica network of seropositives. We have representatives here. Yes. And on behalf of this committee, let me welcome you. As a committee, we have been duly constituted to consider the Occupational Safety and Health Bill, which has been laid in the House of Parliament in 2017. We have received your submissions, and I believe that the members would have had an opportunity to review. But notwithstanding, I am going to invite you to take us through your presentation. And before you do so, I will ask that you introduce yourself so that the record will disclose who the persons are who are appearing before this committee. So I would turn over to you. But first, for the hand side, you introduce yourself along with your team member before you proceed to take us through this document.
Thank you, Mr. Chair. Good afternoon, everybody. Jumoke Patrick, Executive Director of the Jamaica Network of Seropositives.
Good afternoon. I am Tajna Lee Shields, Policy and Advocacy Officer at the Jamaica Network of Seropositives.
Very well, Mr. Patrick, or Ms. Shields, which either are you presenting? Could you now take us through this document?
All right. Good afternoon again, everyone. Thank you, Mr. Chair. So we'll be doing a shorter presentation of what we had presented to the committee based on our policy brief. I will start off and Ms. Shields will end the presentation. The Jamaica Network of Seropositive is an advocacy network which provides care and support for the community of people living with HIV in Jamaica. JN Plus for short is an organization which advocates for the rights and concerns for people living with HIV and is particularly interested in the implementation of this act by virtue of the potential protection it includes for people living with HIV in the workplace setting. In our view, the OSH Act is a critical piece of legislation for the community of people living with HIV, as it has tremendous potential to reduce HIV-related discrimination in the workplace, create an enabling environment for people living with HIV to live healthy and stable lives, and protect the rights to privacy, confidentiality of that particular community. According to the Jamaica Anti-Discrimination System for HIV, JADS, which is a mechanism that our organization operates as it relates to reporting and redress for HIV-related discrimination, the third most common setting reported for incidents of discrimination is the workplace. Therefore, discrimination against people living with HIV within their workplace is a very prominent issue. As there is a clause in this act which will prohibit discrimination on the grounds of real or perceived HIV status, this act would likely deter employers and workers from engaging in a discriminatory behavior, or at the very least would mete out sanctions for those who do. Consequently, people living with HIV will be able to enjoy their rights to freedom from discrimination and to equality. When people living with HIV have equal access to employment and to protections and reasonable arrangements within their workplace, they will possess stable jobs, they can support themselves financially, and are able to afford the necessities which allow them to take care of their health and well-being and to manage the HIV virus. Provisions regarding prohibition of HIV screening as a condition of employment and prohibition of mandatory disclosure are expected to be included in the Act. When these provisions are successfully integrated, people living with HIV are expected to face less pressure to disclose their HIV status to their employers. As such, they can enjoy their rights to privacy. People living with HIV should not be forced to have everyone in their lives know their status and should have the ability to prevent HIV positive status from defining their entire lives. And I'll now hand over to Ms. Shields to continue.
So following our review of the current draft of the Occupational Safety and Health Bill, our organization would like to highlight the following comments, concerns, reactions, and feedback. So for one, the third schedule, clause 103, part 2, from our viewpoint, the amounts of the fines mentioned are too low and are not a sufficient punishment for acts of discrimination, especially the amounts that organizations would be required to pay. So if convicted in a parish court, the individual should be slated to pay an amount not exceeding $1 million, where the organization should pay a fine not exceeding $3 million. However, if convicted in a circuit court, the fine for an individual should not be exceeding $2 million, and for that of an organization not exceeding $5 million. So in any case, a person's human rights are worth a lot more than can be reasonably stipulated in state-sanctioned fines. However, the amount specific to the circuit court, and going back up, that's the $2 million for an individual and not exceeding $5 million for an organization, are more satisfactory. Depending on the gravity of the offense, counseling on other legal actions that can be taken should also be provided. So for instance, any discriminatory action that puts an employee's life in danger or fails to protect an employee whose life is in danger because of an incident occurring while on the job may warrant criminal charges. Legislation such as the Offenses Against the Persons Act, among others, can be used to ensure that workers know how to access justice through whatever means they may prefer. On to inconsistencies regarding HIV testing. So the bill explicitly states that no employee shall, except with his informed consent, be required to disclose any information regarding his HIV status of any medical examination to his employer. It also states that where an employee opts to not submit to testing, no inferences concerning the HIV status of the employee may be drawn from such exercise by reason of the employee so opting. We believe then that the reference to necessary HIV testing in Part 6, which is under non-disclosure, needs to explicitly state what is meant by necessary HIV testing. On to disclosure. So the Act speaks to the right that employees have to not disclose their HIV status. And it also speaks to the responsibility of employers to not engage in discriminatory conduct. However, it does not mention responsibilities of other workers to ensure that they do not disclose the status of a co-worker. Employers should have a responsibility to intervene in any case where a worker's status has been involuntarily disclosed and to take action. And finally, the expansion of discriminatory conduct. So the definition of discriminatory conduct should be expanded. The current definition does not adequately cover the myriad of discriminatory practices which take place in the workplace. And this is applicable to both the general public and more specifically to the community of people living with HIV. The definition should be rooted in human rights principles. To conclude, we urge the government to expedite the legislative process as it pertains to the Occupational Safety and Health Bill. There have been numerous discussions on this matter over the course of the last few years, but we would like to see these conversations pursued with action. It is important that we make note of the fact that HIV is similar to any other chronic illness. People living with HIV are able to live long and fulfilling lives, and they do not need to be treated any differently in the workplace. Thank you.
Thank you, Ms. Lee. Members, it's now your turn. If you have any comments, any questions for JN Plus.
Just a question. Am I correct that you're supportive of the bill as is?
Yes, we are. So if you look at the policy brief, which I think is the copy that you have, we went through a couple accolades highlighting one, how necessary it is that this legislation comes into place, and some of the things we are very excited about where the legislation is concerned. So as we said, it would provide a lot of protections for the community of people living with HIV.
Would I also be correct that you're concerned about the level of punishment, as in your commentary at number 3, commentary on the draft bills,
Section 103.
1, 2, page that not really number. But I think it's the third to last page. It says commentary on draft Ash bill, and number 3, clause 103(2), where you speak to the penalty. You would like the first instance court, if it's a parish court, that parish court be charged up to 5 million.
Right.
Rather
for
than
organizations.
Yeah.
Correct.
Yeah, and are you aware, as the lawyers are going to tell us soon, that the parish courts have a limit as to how much they can fine, and to get to your 5 million, we may have to try all of these cases in the circuit court, which is not something I think most people want, because the burden there is going to be heavy. Maybe jurors and all of that too. But I've thought been given to that. The limit that the parish court has now in law, whether it's HIV related or COVID or broker shop or cocaine.
So it might call for those cases to be heard by the circuit court, yes.
And final question from me for now. You say you need a definition of necessary HIV testing. You are opposed to any testing. Would that be your position?
Yes, that would be our position.
On the matter of disclosure, see, you have made a point here in respect of non-disclosure. Could you just take us through the specific point you're making in this regard? Is it that you're saying that this duty of non-disclosure is not just, or not to be just imposed on the employer, but it should also extend to colleague workers, co-workers?
So yes, it should extend to colleague co-workers, but what we're asking is that the employers have a responsibility to take action where an employee has been disclosing the status of another employee.
Okay.
Just to support that point, because in our work as an advocacy organization and in terms of collecting HIV-related reports of stigma and discrimination, a lot of the times, especially as it relates to workplace, it's another employee bring to the attention of management that this person is living with HIV, which cause problem for this person as an employee within the organization, which in our reports is used as reason to dismiss this person, despite not reporting that is the reason that person was dismissed.
I did say the final question, but there's one that I had lingering.
Yes.
As an advocacy organization, do you have numbers and data as to people who have been discriminated against in the last 3 or so years?
Yes, member. What I did was to bring last year and what we have up to this year. So in 2019, and like I said earlier, we operate a mechanism called JADS, Jamaica Anti-Discrimination for HIV, which is a reporting and redress system for people living with HIV who feel they have been discriminated against for whatever reasons in whatever settings. So in 2019, we had 2 cases for schools, 2 in homes, 25 in communities, and 16 in the workplace. That's for 2019, and for 2020 so far we have 1 for school, 3 for home, 14 for community, and 6 for the workplace.
And to the workplace, through your chair. Have any of them involved termination, and have there been follow-up on those terminations? For example, reference to the Ministry of Labour and the Industrial Dispute Tribunal. If you have that data, it would be helpful.
Okay, so let me look at 2019, and I'll give you the nature of the incident. So 24 of those were breach of confidentiality. 3 persons were forced to leave their job, and 4 encountered physical violence.
Describe from a forced to leave their job, fired, or they say, I can't take this.
It can be both.
Yeah.
I don't have that data directly now, but we can check that if that's a requirement from the committee. Yeah.
Member Longmore, I recognize you.
Chair, just a bit of clarification in terms of the non-disclosure regarding status, etc. And again, welcome, appreciate your presentation again. With respect to workers, and I'm just trying to make sure we're clear on what obtains or what should obtain, and also maybe to get your opinion in terms of health care industry dealing with blood and blood products, workers who engage in such lab works, etc. And someone has now become positive for whatever reason. Should they disclose? Because in that scenario, they could be putting other lives at risks just by mere incidents or accident that could happen.
Thanks for that question. We do encourage disclosure depending on the context. As it relates to healthcare and those types of services, we tend to encourage people living with HIV to disclose.
I should say that, I mean, this could also be a policy decision specific to that, or guidelines specific to that type of industry. But
Right.
I wondered, what is the position of your organization with respect to disclosure in that context?
So we do encourage that. It's a healthcare issue, especially for people living with HIV. When it comes to healthcare, they spend most of their lives accessing healthcare, depending on where they're from across Jamaica. And already within the system, their records would have been there as to being somebody HIV positive. Outside of that, though, they may, for example, decide to get life insurance. And
No, I mean, like, let's say a phlebotomist is positive.
the
The other way around.
right.
And that person, so a phlebotomist is somebody who pulls blood professionally, yeah? So that person is positive and is going to be in their trade engaging in the use of blood and blood products that could go to patients.
Right.
Is that person obligated to disclose their status?
No. No. So what we stand by is the standard guidelines and protocols as it relates to such public health issues, in taking the necessary precautions so that cannot happen.
Right.
We stand by that. But outside of that, we don't ask the person living with HIV in such a situation to disclose their HIV status. It's not necessary. Once necessary precautions are taken and the preventative measures and the guidelines and the policy or protocols, whatever it is, are followed, then we're okay with that. Because we don't ask people to disclose any other thing, any other virus, any other disease.
I fully grasp the both sides of it, but no other situation can put someone at risk the way that directly can in terms of their work that they're doing. It's like the level of awareness, like the precaution that as a practitioner, as a doctor takes when they glove up. You know, it's another story if that needle sticks you. It's a whole another level of engagement. So I'm just wondering what is the opinion in terms of that risk that may be posed on the person who is receiving the treatment.
So in reading the act, one of the things that we highlighted was the fact that the act explicitly says that your HIV status cannot be a deterrent to you working in any field. So if it is a case where you are able to work in the field, just knowingly taking the basic precautions that everybody else takes, because a person living with HIV who is a phlebotomist is not going to take any other additional precautions than what the other persons would take. It's the same basic precautions to ensure that nothing happens, that there is no transfer of blood.
Just to highlight though, Senator, if a phlebotomist is going to be drawing blood, if it is by accident, they stick themselves when they're pulling, they would have to discard of that needle. So I'm not sure if that would, I'm not sure, as you said, they would be taking all the precautions to protect the other person. And if it is, any of us goes to get our blood drawn at all, and the needle, when they pull it out and it sticks, they would have to discard of it. So I'm not sure if that would really...
It's important to know that would happen regardless of their HIV
status. So I'm not sure if that example is a good one, or in that respect, if that would even, float.
Yes, Member Gill, you.
I just have a question seeking clarity and then a comment based on one of the recommendations. But the question, going back to non-disclosure, your statement is that no employee shall, except with his informed consent, be required to disclose any information regarding his HIV status of any medical examination to his employer. That's one. But then he went on to state, where HIV testing is necessary, the employer shall ensure that the employee undergoes appropriate pre- and post-test counseling. I just want to understand the circumstances that you're speaking about where you say where HIV testing is necessary.
So based on our knowledge, the security forces currently perform that as it relates to testing. And so if in such a case I am being recruited for the security force and I'm tested positive, we're asking that that measure be in place, because there are going to be situations where one or two or how many turns out positive.
It's for the purpose of recruitment then, that the test becomes necessary under those circumstances.
Well, personally, I wouldn't say it's necessary, but it's being done. Right.
My comment is directed under your clause 5, final comments and recommendations, where you cited, we urge the government to expedite the legislative process as it pertains to OSH bill. There have been numerous discussions on this matter over the course of the last few years, but we'd like to see this conversation pursued with action. Establish and organize a session in the Senate to conduct final review of the bill and vote into law as soon as possible. I can understand and appreciate the concern, because we share the concern also that this piece of legislation has been there for the longest while. But I wouldn't want you to leave with the impression that even you being a part of this consultation is not important and is not seen as a rush, and that we have to go through a particular process where the bill gets the type of probity that it deserves and that you're a part of. So I wouldn't want you to leave saying the fact that, you want this thing to be hurried up and we go through with it, because if we were to have done that, then you being here this afternoon would not have been a possibility.
I agree with you, member. In terms of our position and what we do, we find it very critical and important to, at all times, when it comes to policy, when it comes to legislative process or an act, that the government of the day should act accordingly and do as best as possible to ensure that all these measures and all these policy documents and acts are in place to protect especially the community of people living with HIV.
Members, any other questions? All right. I want to thank you again for coming, for appearing before this committee. I am sure that the comments you have made, they will be duly considered and will be incorporated in the legislation where necessary. So again, I want to thank you for appearing, Mr. Patrick and Ms. Shield, for taking time out to appear before this committee. So, yes. Yeah, ma'am, yes. So you are excused? Yes. Members, before us is the matrix. I have received a copy. I believe that there are some copies here. I think it is important that we make a determination as to the clauses, if any, coming out of this matrix that we need to perhaps consider, if it is that we have not yet considered it. I believe, in agreeing to what Member Skeffrey has said, I believe that substantially we would have completed this matrix. But I think even before we ask the ministry to respond, we need to isolate those clauses that we may not have touched during our deliberations. Okay. For those of you who have not been served with a copy, other copies will be made available shortly. So, members, in terms of the form or the approach that we will take now, if there's any other suggestion, let me hear. But I believe we should just isolate those clauses that we would want to hear from the ministry on. And that is if we have not yet touched it. But I believe substantially we have. But out of an abundance of caution, I hear from you. Yes. Yeah, you, if it is that there's a different approach to take to this matrix.
That's for trying to identify it. I know we have started looking at many of the stakeholders' view, but probably to guide us is from the minutes or the notes as to what clause we have stopped or which view we didn't take into consideration. For it to be effective, so we could look at those, but to go from memory now would be difficult for me, certainly. Well, so I don't know if the notes could reflect. I know we started to, we looked at the matrix, but I don't know if we did it for all the clauses or for all the submissions. But I know we did, before we started the clause by clause review, we were looking at the matrix, and then I think a suggestion was given that
The
we
legal team
integrate both.
states.
I don't think we had completed it. So, and I don't know if we had accepted or rejected all the views, but so I don't know if we're going to start from scratch again. I don't know what's the suggestion, but
Yes,
I
Mrs.
can-
Sullivan.
What I can recall, Chair, isn't it that we had stopped when we were going through the interpretation clause, because we had decided to leave it until the end, and then we had gotten the ministry and the OPC and the AGC to just go through what our concerns were. I think that is the approach that we had taken. So we hadn't gotten past, I think, is looking at the interpretation provisions.
And that will be section 4. What I do recall is that we stopped when the suggestion was accepted that the legal teams meet and they would prepare a brief for this committee. But we could, if we could perhaps. But I'm recommending that we would overlook clause 4 for now, and we will pick up at page 12. Since clause 4 touches on concern the definition, and we just look at the different clauses and whether or not. Can you just plug this in for me? Plug it. And given the layout of the matrix, we will just take the comments from the different groups as is set out in the matrix. Page 12 of 106. It's page 12 at the, yes, page 12 of the matrix. Yes. So we're picking up at clause 5. I believe that this is something that would have, just looking at it, and Joshua and Mr. Ken Garmon, I believe we would have dealt with it as part of our discussions. And I think we actually had looked at this provision too. What I do know is that the discussions were had. If it is that the ministry is to come back, then certainly the ministry will come back. So what is important at this stage is whether or not we had the discussions.
Based on my matrix, the pages start in a descending order. No, that makes sense.
Well, it is okay. Very well. We're moving now to clause 7. Yes. Yes, I think we had the discussion and the ministries to come back on it. Yes, and we can just look from Mr. Conlive straight to Jeff or the Ministry of Education. if we go across on page 13, and if we look at the comment from the JCTU and the suggestion that the definition of worker should specify all categories of workers, page 13, in ministries, agencies, and departments of government, executive agencies, and so they were seeking to have the definition of worker include these. I do not know if that was part of our deliberations.
Discuss the crown. We were saying exactly this.
And the act would bind the crown.
Yeah. So we were saying, let's try the wording that include MDAs.
But this is definition of work. I don't know if Mrs. Bennett Campbell, if you are able to have if you have a comment on the definition of worker, whether it is sufficiently wide or this is something that we may have to. From JCTU on page 13. Okay. Yes, so she also have an observation. Yes.
Just saying I'm interested in the observation made by JPS and how we would address that too, if we need to.
Yes. So it appears as if we will have to revisit clause 7 by virtue of what is being highlighted here.
I don't know what you mean by revisit and why.
Well, I think the challenge is that by virtue of the comments here, I doubt, well, they have indicated that the ministry is not in a position to respond to these concerns. No. So as a committee, we could look at it, but in terms of hearing from the ministry has indicated that it is not in a position to.
Am I hearing that the ministry is resigning from the position that contractors and subcontractors are to fall under the ambit of this legislation?
Absolutely not, Member Brown.
So what is there to look at?
Yes. Yes.
I'm trying to figure. Could you tell me where you are? I'm trying to still find where we are exactly. 14. Page what? 14.
Put your attention to Mr. Gammon, which would be 1, 2, 3, 4, 5, 6 column down, and the JPS score position, which would be the fourth.
Mr. Chair, there's a point here. Before we are going through what each stakeholder said. And for example, we don't know if the ministry has a position on each. I think rather than go through and what the ministry has a position and then say we revert. I think it's best that they go through the matrix, look at each, and make a recommendation, then we can clarify and come to a position.
Right.
I don't want to just go through the document and revert 90% of the document, and then next meeting we will go through after there's a position. So I think if we are not ready to go through this document, then we just say so, give them time to look at what all the stakeholders have said, and merge, and then we now can integrate with a position. Because I think what's important after we go through each stakeholder, as a committee, we say yay or nay.
Yes, I agree with you. I'm just being advised that, in fact, the ministry had put forward a document.
That's what I'm saying.
That's
why I said to you that I'm confused. I remember.
Yes.
Not probably not for the entire, all the clauses, but I remember that we had the matrix, the ministry had its position, legal team had, and we were accepted to a certain point down the wicket.
Yes.
But what I'm seeing here now, we're starting all over with the stakeholders and they gave us some recommendation and we accepted and rejected. That was the critical part that we started after the submissions were made. So the notes have to guide us, unless we are just going in a circle again.
We do not want to do that, Member Skeffrey. I'll hear from the ministry before I come to you, Mrs. Seeley Brown. Yes.
Yes, Minister, I know we had put forward an original position at the beginning after stakeholders, but then we went into the clause by clause that identified some weaknesses. So some of our initial position would have changed and some would remain the same. We'd prefer to revisit our matrix because this started before the clause by clause when more weaknesses became evident. So yes, we put forward a submission at that time, but it's before the clause by clause. So we would want to revisit this matrix, see what we changed, what we agreed with, and fix it and come back.
That is reasonable. So what is before us is that the ministry will look at the matrix as the stakeholders have commented. They are now going to communicate their position. And all of this will be contained in a document to be circulated to the members, which should be available for the next meeting.
Chairman, of course, that they would also take into account the views that evolved from the committee. Because take, for example, the issue of do we exclude the security force members? That's something that we discussed. We didn't take a decision, but that ought to be part of the work that they come with.
Yes, yes. All right, so I think we have developed a roadmap to, going forward in respect of the matrix. Where that leaves us, members, is... Yes, Mr. Simmons.
I was just asking you kindly, Chair, to repeat that roadmap for clarity.
So the ministry is going to provide us with a revised document in respect of its position having regards to the stakeholders' comments. And Member Brown has indicated that, where as a committee we would have taken certain decisions, that be included in this document too. What's that? Member Cuthbert?
Well, I just want to, listening to all of this, I just want to commend the people who will be doing this work. The technical team. I think a lot of people don't understand what goes into passing these bills, these legislation, what goes into it with the work that you actually put into all of this to make it happen, to make it a possibility. And I just want to, as I said, listening, I'm overwhelmed, but just listening to what you have to go and do, I just want to commend the team.
And underscore how long the process takes. A lot of persons, one of the biggest criticisms is that we take so long to write our laws and to bring them up to date, etc., etc., especially something of this magnitude.
Yes, so, this is detail and hard work.
Yeah.
No doubt about that. But certainly the team from the ministry, along with the other legal teams, we continue to give up our best. So next week, though we may not complete all the clauses, I'm almost certain we will have something to work with for next week.
And if I might add, Senator Skeffrey was saying it's like running the 100-meter. Yes, but let me tell you the kind of hard work that goes into running a 100-meter. It's a hard work, even though it's something that you're built to do, and it's easy in a sense. But because it's what you do, you have the fast-twitch fiber, you have that genetic makeup. However, the work that goes into running that 100-meter and running that 10-7 or 10-8 is another thing, and I think it's the same thing. So I know that it's not easy.
Yeah. All right. Members, we will take the adjournment now until Monday of next week, the 13th at 10 a.m. for another extended day, 10 until 4. So Member Longmore has moved and seconded by Member Skeffrey. This meeting is now adjourned.